Hello, hello. Welcome. It's 2 o'clock. Thank you, everybody, for tuning in. This is our last webinar of 2024. As I've mentioned before, we probably trained over 1,000 people this year, so I'm very happy to see such a good turnout, knowing that it's December and slowly getting into the second half of December. We've got Yvonne from Gilchrist Connell with us today. To give us a very, very good sense of what's coming in 2025, and also to give you as many practical tips on how to get ready for all of those things that are coming. All right, let's get started. So you already know me. I'm Tatiana George, the CEO and co-founder of Curium. Curium is more than just tech, as we like to say. It's your partner and specialist in all things risk and compliance. And Yvonne, a principal at Gilchrist Connell. I'll let Yvonne introduce herself again to those who don't know you.
Thanks very much, Tatiana. As Tatiana said, my name's Yvonne Lamb. I'm a principal at Gilchrist Connell, which is an Australian insurance law firm, and I head up our corporate insurance and insurtech team, specialising in providing legal advice to the insurance industry across corporate and commercial matters and financial services, regulatory and compliance issues. I'm very pleased to be co-presenting with Tatiana and Curium again for this webinar today.
So Gilchrist Connell and Curium have actually quite a strong bond over the last couple of years, both in working together for external clients, but also working together on building our own database of legal obligations and deciphering it with practical examples for our clients. All right, so a very packed agenda for today. We will not be able to cover everything in the next hour. So we've picked the most relevant things in our view. However, we'll ask you in the middle of this webinar, what do you think is important? And in our view, some of the regulations in here, they almost deserve a separate hour to themselves going forward. So we'll ask for your opinion of what those are. So now just looking at this, we'll start from kind of a message from ASIC. We were debating if we also want to put EPRA and add, different regulators in here, and we decided not to because it would be too much. But just kind of maybe on the personal note, I'm very happy to announce that I'm now part of the ASIC's digital finance advisory panel, where 6 regulators meet regularly with industry associations and practitioners like us to discuss how they're going to be regulating things that are already happening, with an example of AI or digital assets and things like that. So very pleased to be there. Just started in, literally in December. So I hope I can share some of the views from, what the regulators are actually thinking. So we'll start with ASIC. We'll start with enforcement priorities and strategic priorities. DDO, again, deserves its own special mention. It's kind of keeps going. And also, we want to present a very brief overview of the reportable situations regime and a bit of learnings from there. Then we'll go into a few things. So in Chapter 2, we have picked some of the regulatory changes that have already been confirmed and are coming for sure, and give you a sense of it. So with asterisks, we've marked those that we're going to stop and discuss today, but the other ones are not, not less important, but potentially, as I said, deserve a whole separate hour in themselves. So we're going to speak specifically about the Cybersecurity Act today, privacy reforms, and consent for commissions. The other things, as I said, please let us know if you want us to run separate things on them. And finally, what do you need to keep on your radar? So things that we know are going to happen, but there has not been a law or a commitment on when those things will be regulated. So we've picked up 4 topics here, and we're going to go in detail only in the ongoing GICOP review, just because we believe it's one of the most comprehensive ones, and hopefully we'll have some clarity soon on when the changes are going to come. Now, before I get into this, look at this list and please let us know how you feel about your own readiness of this. And we're just going to launch a poll. It's anonymous, so don't worry if your answers are not on the top. It's more for us to get a sense of where we can help you most. So please let us know what you think. I'll read out in a little bit how people feel about things. So things are still changing. We have a few people who are very ready at the very top, but the majority is probably around the middle. On track, not sure. Okay, so we've got majority of the people, they feel that they're on track with regulation. Or maybe that's why you're tuning in into this webinar. It's a self-selection bias. Those who know what they're doing. I'll keep it running and you can answer the question. All right. Thank you. So I think the consensus is majority of people on track. 19%. Oh, okay, they're still running. Yes, almost 50% of people feel on track with some equal distributions to the I don't know where to start versus I'm ready or almost there. So let's start deep dive on some of that. So let's start with ASIC. What does ASIC tell us for the next year?
Thanks, Tatiana. Really great to hear that most people are feeling on track with everything that is about to come our way. I know that the industry has gone through a lot of regulatory reform over the past few years. And, just last month, ASIC has announced its enforcement priorities for 2025, some of which are still quite relevant to the insurance industry. And these priorities, as you'll see on our slide, they really include a focus from ASIC on pursuing insurers who are failing to deal fairly with their customers, failing to deal in good faith with them. So this is still continuing to be an area of focus for ASIC going forward and has been the case for the past couple of years. They are also looking to pursue misconduct, which poses a high risk of significant consumer harm, particularly where there's targeting of financially vulnerable customers, as well as misconduct that can affect small businesses and their creditors, and importantly, licensees who are failing to have adequate cybersecurity protections, which makes a lot of sense in the context of the fast evolving technology and AI that is becoming more common and mainstream in our industry. ASIC's also looking to pursue any systemic compliance failures by large financial institutions that could also have a huge impact from a widespread consumer harm perspective. So the reason why we wanted to start with this is because it's just a snapshot that sets the tone and context for some of the topics that we're going to be going into more of the deep dives on today. And for a lot of you, these themes are not going to be unfamiliar for those who've been following ASIC's enforcement actions in the financial services sector over the past few years. We've seen, obviously, some increasing action by ASIC against insurers for things like unfair contract terms, which cuts across a few of those regulatory enforcement priorities. There's been cases over the past year against auto and general insurance, which ASIC wasn't successful on in terms of getting the unfair contract term bar met in relation to the term that was selected for that one. There's also been a recent case against HCF Life where ASIC was successful on misleading conduct allegations against HCF Life for a pre-existing condition term, but they were then unsuccessful on the unfair contract terms allegations against HCF Life. So what this does indicate to us is that ASIC is looking to test the boundaries of where the legislation or the regulatory requirements are, particularly for the insurance industry, where things like unfair contract terms are relatively new developments, and just so that this can send a signal back to the industry about terms that they might themselves have in other policies, just so that everyone's on notice on where the line might be, even though that is still an evolving field. So Tatiana, I might just turn to you for any observations from your end about what this means in practical terms for the industry.
So I guess none of the themes is new to you. It's all been there. It's just more where does ASIC turn, their eyes this year. So funnily enough, the one recommendations we put at the top is never forget about the customer and always evaluate the customer impact. I'll tell you why it's so important. So ASIC recently ran the study on AI, implementation of AI in Australia, and they've picked a few licensees, something like 600, and they analyzed various models and what they were doing with AI. And I'm not sure if it's a surprise or an expected outcome, but very few of those licensees actually analyze the impact on the customer through whatever they were doing. And it's kind of shocking because, the only reason we're there, all of us, is to serve the customers. And yet when it comes to practical changes in the business or testing, some new funky tech, it's actually not front and center for a lot of firms. So I guess anything you do, just never forget the customer and how, whatever you do is going to impact them. Then for sure, small and or vulnerable customers remain a big focus, and we'll hear the same echoes through the GICOP review and also the responses to the 2022 floods. It's an ongoing topic, and we anticipate at least the General Insurance Code and potentially later the Broker Code will have stronger provisions for vulnerable customers in there. Cybersecurity, again, you've got your writing on the wall. There's a Cybersecurity Act. It's all now in the law. What you were supposed to be doing, or all of us were supposed to be doing in our risk practices before, is now in the law. And yes, of course, linked to privacy. And finally, we see it everywhere. Even if you're a 2-people firm versus a 1,000-people firm, just build robust compliance early. The more you know about it, the better foundations you have, the easier it's going to be. But every new regulation and every new report or requirement, you're just widening the gap if you don't have a really good foundation. All right, let's move to the next one, strategic priorities.
So in conjunction with those regulatory enforcement priorities we just talked about, ASIC's also released their corporate plan for 2024 to 2025, but it actually sets out a more longer-term roadmap about their priorities over the next 4 years. So it's a very useful way to just get that helicopter view in a bit more detail about not just the regulatory enforcement priorities, but also where ASIC is dedicating resources and expecting licensees to also follow suit in terms of different parts and aspects of their business operations. So we've got 5 strategic priorities, which are listed on our slide, and we're going to do a deeper dive on strategic priorities 1, 2, and 4, which we think have particular relevance to the insurance industry. So the first one is the improvement of customer outcomes. So ASIC is really going to be looking to undertake some key activities in pursuit of improving customer outcomes for the industry. And that's going to include ensuring compliance with product design and distribution obligations, or the DDO regime. That's going to be one of the topics we're going to focus on shortly in this session. ASIC's also going to be supporting the Australian government's response to the Quality of Advice Review, which is another topic we'll cover off towards the end of this session, because there's been some legislative reform on informed consent for retail commissions in this space that will be coming up, taking effect in 2025. As Tetiana has mentioned, they're also going to be taking action against insurers in relation to claims handling, particularly home insurance claims, which obviously has been getting a lot of airtime in the media, and politicians are also weighing in on the conversation because it's impacting a large segment of the Australian population, particularly with severe weather events that Australia has experienced a lot of over the past few years. And as a flip side of that, ASIC is also going to be monitoring the adequacy of internal dispute resolution arrangements, which are required under ASIC Regulatory Guide 271 for retail clients. And they have already started publishing observations from IDR data that's been reported by firms to date to ASIC, and that was contained in a report that was issued earlier this month. Then turning to strategic priority 2, that's a focus on addressing financial system climate change risk. So as most of you might have heard, there's going to be an upcoming introduction of an Australian mandatory climate-related risk disclosure regime. And that's due to start on the 1st of January 2025 for large Australian companies. It's a stage process, so different cohorts of large Australian companies that meet certain financial and employee thresholds will be required to start reporting on climate-related risk disclosures in a stage process from 2025 through to 2027 as a start date. So as a result of that, it's no surprise that climate-related climate change risk has been included as a focus area for ASIC as it goes through that stage implementation process over the next few years. And what ASIC is going to do to support the introduction of the regime is to start developing regulatory guidance, assessing applications for relief from those new requirements, and supervising compliance by those entities that are starting to become captured by that regime going forward. So I think that certainly is, in answer to Tetiana's question earlier about which topic probably deserves its own webinar, that's one that I think there would be a lot of interest in what that means in practical terms for different parts of the industry. And then ASIC is also planning to continue its efforts in deterring greenwashing and sustainable finance misconduct. And they plan to do this by undertaking surveillance activities and enforcement actions. And over the past year, we've already seen some successful results from proceedings that ASIC has brought against various financial institutions, including the first greenwashing case that was pursued against Vanguard, which then resulted in a record $12.9 million penalty earlier this year. And then lastly, ASIC is going to be examining in more detail how general insurers are actually handling customer complaints and responding to recommendations about claims handling following severe weather events, which follows on from the various previous reviews into the industry, but also bearing in mind claims handling only became a regulated financial service over the past couple of years, 1 January 2022. So ASIC's now playing catch up on what that means and how that can be improved going forward. Strategic priority 4 is the other big one, advancing digital and data resilience and safety. So in this space, ASIC is going to be supporting APRA's focus on this area, which is through the incoming Prudential Standard CPS 230, operational risk management, which is one of the topics that appeared on the agenda as one that we're not going to cover in detail today because we've previously run a few joint webinars, Tetiana and myself, on this topic, and that's due to start on the 1st of July next year. Instead, today we're going to really focus on what ASIC is doing outside of the support work in the CPS 230 space. They're also going to be planning to implement a supervisory cyber and operational resilience program. They want to support regulated entities by reviewing cyber resilience of various sectors and industries, and they'll be sending letters that are based on the findings of their surveillance in this space. And they plan to also improve their information sharing initiatives with APRA to make sure it stays coordinated across the financial services sector. As Tetiana touched on before, there's also going to be a real focus on how financial services entities are using AI and advanced data analytics associated with different ways that these technologies being built into operations, but also what's happening from a risk management and governance perspective. So ASIC has recently released a report in October this year where they looked at AI use by 23 Australian financial services licensees over the past year, and they've already identified gaps in the AI governance that's supporting the use of AI by those licensees. So what ASIC has found is that AI governance is usually either lagging or maybe perhaps being updated at the same time as those technologies are being integrated into operations. And that's quite a concern to ASIC because it has the potential to amplify existing risks to consumers, given the context of consumer protection and harm, which is a real focus for ASIC going forward, but also to introduce entirely new risks that may be unintended or unforeseen as a result of the evolution of the technology and the different use cases that are being experimented with through the industry. So given the context is ASIC is expecting most licensees or a real increase in the use of AI over the next year, with 61% of licensees who are reviewed planning to further increase the AI use over the next year. ASIC has put out a signal that they're still expecting AFS, Australian Financial Services licensees, to adopt AI in a safe and responsible manner, it needs to still be in accordance with your appropriate risk frameworks and practices under our existing technology neutral financial services legislation. So they're not expecting the fact that we are currently still in the process of hearing from the Australian government on the proposed consultation on any mandatory guardrails that might be put in place for higher risk use cases shouldn't change the fact that if you're a business that is planning to already integrate AI into your business operations, there are already existing requirements that need to be met regardless of what technology you're using to deliver your financial services. I might just turn to Tetiana for any thoughts from your end on that.
Yeah, so I'll just expand a little bit more on AI. So ASIC's observations are actually very interesting in when it comes to practicality. They found that those gaps that Yvonne mentioned in the governance were actually smaller for those entities who have an overseas presence, particularly in the EU, because as of now, the EU AI legislation is probably one of the most comprehensive one and is viewed as a, for now, kind of golden standard in the world. So that's one. And the second one, ASIC was very clear. If your compliance, background and frameworks are not strong to start with, AI is just going to make it worse. So this is kind of this is where it goes. And finally, so the standards that Yvonne mentioned, we're happy to provide you with a link to those. Australian government has released voluntary code on safe and kind of mindful use of AI. So we're happy to share those with you if you wanted to start looking into it, because I'm sure probably majority of the people in this virtual room today are already playing with AI. It's just good to see what are the good ethical principles when you do so. In terms of other things, I guess, practically speaking, claims has been and will be one of the biggest, I would say, problem kids in the industry. From the regulatory point of view, it's probably 70% of the breaches and things that we see happen in claims. And also all the scrutiny and the bad press over the last year is clearly identifying that that's the case. So we say if we were, to focus somewhere this next coming year, it will be definitely claims, investing in better claims processing systems, training, outcomes, and so on. One other thing, so we've been in the market, we started with complaints management module over almost 4 years ago, and what we've seen is, unfortunately, spotting of the complaints still remains an issue for a lot of people. And even if your frontline people spotted the complaint, they haven't necessarily logged it and treated as such. They might have kind of brushed it off and so on. And this is what gets consumers really angry. And this is where, especially in high risk and high impact scenarios like, floods or big natural catastrophes, this is where people get really kind of driven to the edge a lot of the times. And also multiple representatives of AFCA have spoken out and said, look, communication. You cannot over communicate in those scenarios, and that's what they advise people do. Greenwashing, I won't stop too much about it. On the topic. The importance about this is, whilst you might not be amongst the first entities to report on your CO2 emissions or things like that, highly likely that you'll start seeing requests that are coming your way from larger entities who report and for whom you become what's called a scope 3 participant. So if you're interacting with those people in one way or another, you might start seeing different requests and start kind of gearing up for it, for how are you going to disclose your own CO2 emissions, how are you going to look at your own climate-related risks, and so on. So whilst for very large companies, the due day is, well, it starts next year, but then the official reporting period is a year later. So you could say there's time, even though, people might disagree. But I'd say even if you're not amongst the first cohort, start preparing for this. yeah, and cybersecurity, again, I'm not going to dwell on this. There are many, many webinars and many new entrants into the cybersecurity market, both from the prevention point of view, but also from protecting you and ensuring people against that. All right, DDO.
Right, so now we're just going to do a deeper dive on ASIC's focus on compliance with the DDO regime, which commenced in October 2021. So as many of you would know, the DDO regime is intended to help consumers attain the appropriate financial products by requiring issuers and distributors to take a consumer-centric approach to the design and distribution of financial products. So ASIC has already had a successful test case result this year against American Express, which was ordered to pay $8 million in penalties for breaching DDO regime requirements related to two David Jones co-branded credit cards. The Federal Court of Australia found that in that case, Amex had breached the DDO requirements because it ought to have known that a high level of cancelled application rates reasonably suggested that target market determinations for that product were no longer appropriate, and then it failed to stop issuing those credit cards when it had not yet actually reviewed the target market determinations. So over the past year, ASIC's been a lot more focused on the quality of the target market determinations that are out on the market and how it links back to the products that are there. But now they're shifting their focus to the next obligation, which is on issuers to take reasonable steps to make sure that the product is being distributed in accordance with the target market determination. And to meet this obligation, issuers will need to implement effective arrangements that are likely to direct the distribution of the product to the target market in mind. And in September this year, ASIC has already issued a call to action on issuers to make sure that their distribution practices are up to scratch. And this is following on from ASIC's surveillance of 19 issuers, and that included some insurers who issue what they consider to be high-risk products over the period October 2023 to August 2024. And they looked at what those issuers were doing in terms of complying with their reasonable steps obligations. So on the whole, while ASIC did find that these issuers were making progress compared to previous reviews into the industry to comply with these reasonable steps obligations, there were still some concerns and areas for improvement that ASIC identified. So firstly, they noticed that there were limited due diligence arrangements that were being implemented by those issuers to assess and monitor third-party distributors' ability to actually distribute the product in accordance with the target market determination. And some issuers of high-risk products were actually relying on broad search terms in online marketing, which ASIC had took issue with in terms of not being an indicator of good practice. ASIC also noticed that there was a reliance on poor quality questionnaires that didn't truly seek to understand a consumer's attributes. And there was also limited monitoring of consumer outcomes to inform product governance arrangements and also to change any future distribution practices based on the outcomes that were being experienced today. So as a result of all of that, ASIC has called on issuers to be reviewing those observations that have been made in their report, including any better practices that were identified amongst those issuers that were reviewed, and really to look back on their existing arrangements and consider if those issuers should be amending the practices to make sure that they're really uplifting the arrangements in place for selection and supervision of distributors, making sure that you're training your staff appropriately, that you're looking at your marketing and promotional materials with a critical eye, and making sure that if you're using questionnaires or using information, that you're actually making sure that those are fit for purpose and you're monitoring the outcomes that come off the back of consumers who are purchasing the product or having those products distributed to them. So really the key takeaway in this space is that issuers should be really considering how to integrate this reasonable steps obligation into the broader compliance and broader governance frameworks that businesses should have in place already. It is a relatively new obligation, but the things that it's directed towards can integrate with your existing contracts or existing policies and procedures and processes of oversight and supervision. But really it's what ASIC's looking for is to show that you are actually taking steps to address any identified risks of distribution that are not consistent with your target market determination, which is the core of what those obligations come back to.
So one thing I can add very quickly here. So Australia is one of these interesting countries, you know, when we joke over-regulated, under-regulated at the same time. So what Yvonne just raised here is the point. Distributors are officially not regulated as a financial service here. However, in other countries they are. And so if they're not regulated here, the whole burden of control and oversight falls on those who are regulated financial services entities. So it's just an interesting fact for you to remember. All right, let's go into reportable situations. What have we learned?
ASIC commonly, they publish 3 editions of their reportable situations regime data now. This year they published on Halloween. It seems to be a trend. I think it was Halloween last year as well. So the purpose of this report really is to provide high-level insights into trends that were observed by ASIC in the reports that have been lodged by not just the Australian Financial Services licensees, but also credit licensees about self-reported matters. So these are your breach reports or reportable situations. This last report covered the period 1 July 2023 through to 30 June 2024. And as with the previous years, ASIC has chosen not to name and shame anyone in particular from a licensee perspective. They've just provided data at that sort of broad, high-level trends perspective, and they don't plan to issue more granular data at this point. They have indicated that this approach could change in future years. It just depends on how the regime matures. So during this last reporting period, there was a total of 12,298 reports that were submitted to ASIC, and they reported that they had paid a total of around $92.1 million in compensation to approximately 494,000 customers in relation to breaches reported during that period. Now, at a glance, as you'll see from the slide, there has been an increase in the percentage of AFS licensees who have reported under the regime compared to previous years. So at the very beginning, financial year 2022, the first year of the new enhanced reporting regime, only 9% of licensees were reporting. We're now up at 14%, although that's only a slight increase from last year's 13% of the population. One thing to note is that there is still a significant variation between the reporting by larger licensees who still lodge a higher proportion of the reports compared to smaller AFS licensees. So that does indicate that perhaps it's the larger licensees that have really invested into the systems, compliance processes, technology to identify breaches, which then results in a higher proportion of reports being made by those larger licensees. But it is still quite significant. So the stats at the moment, based on the last reporting period, it's 81% of licensees with over $1 billion in revenue who have lodged reports this year, compared to 10% of licensees with $50 million or less in revenue. So quite a stark contrast there. ASIC's still quite concerned that early identification of breaches is not really happening, because there is a trend that breaches being identified from internal sources, such as compliance activities, has actually decreased by 5% during the reporting period. So it's gone from 78% to 73%, and that indicates that licensees might not be proactively identifying breaches early. And within insurance businesses, the clear trend is that the reportable situations relating to general insurance products are being largely driven by personal lines insurance products. And as a whole, general insurance products make up about a quarter of the total reports, and financial advice only consists of about 7% of the reports. Life insurance products only 2%. So quite a significant difference between the different sectors of the industry. And within general insurance, it's motor vehicle, home contents, and home building insurance that were ranked 2nd, 3rd, and 4th, respectively, in the list of top 10 most reported products. I might now turn to Tetiana just to give some commentary on what that means from opportunities to improve for the industry.
So we are, practitioners on the ground, and specifically the identification of issues early is, in our view, one of the biggest gaps in the industry. And we see it absolutely as an opportunity, because when you know about something very, very early, you have a much higher chance of never allowing it to become a reportable situation in terms of customer impact or any other negative impacts of that. For more than 3 years, we've been going around the market and, preaching the mantra, see something, say something. And up until now, in 100% of our clients, we were successful in getting people to become an effective first line of defense to tell their heads of compliance, risks, or operational managers when something goes wrong early, to almost tell it in real time. And we know for sure, whilst the overall number of incidents in the organization rises significantly, kind of one of my strongest examples is one of our clients had reported 3 breaches in 15 years of existence, and after starting with us, they found 47 in 3 months. So that's kind of the indication of you'll see a lot more if you do this early and proactively. However, you'll probably see a lot less the ones that are resulting in these massive issues that need to be reported to ASIC. And then second thing, to Yvonne's point about large versus smaller firms, again, what we find almost the root cause of why things are not being spotted as often in the smaller firms is education. Because just compiling and understanding all of your different obligations will take a long time and would give or require a significant amount of technical training and almost reading through the laws. I was just joking this morning, I printed probably 30% of things that are new, and this is the small pile. So you can't expect that from everybody, right? A large organization have people who do this full time, and smaller usually don't. People multitask and have, multiple hats at the same time, especially on the operational level. So in our view, that's a very big gap. And that's why we've so heavily invested in these webinars, to give you a sense of, what does the law say? What do you need to do, and inform you about kind of consequences of actions or inactions that you're making on a day-to-day basis in your business. So education and early spotting of incidents are our 2 kind of main reads from this. Before we're going to go into the second chapter, and I know we're running short on time, I just want to suggest, please pop your questions in the chat as we speak, and we'll try to pick them up as we go, so we don't, queue everything up until the end and then I switch off the meeting before you finish typing. I know this happened to people before. So please put them in and we'll try to address them as we go. All right, let's go into the deep dives on confirmed regulatory changes, and let's start with the Cybersecurity Act.
Thanks, Tatiana. So this Cybersecurity Act is a very recent development in the space. So it only passed and received royal assent on the 29th of November 2024. And it has now become law, but there are different commencement dates for different parts of the obligations. So the establishment of the Cyber Incident Review Board and the voluntary use of cyber incident information on our slide there, those aspects have already become effective as of now, 30th of November 2024. But the other headline items that we will go into today from a practical perspective, it's the mandatory reporting of certain incidents. So that one is the introduction effectively of a mandatory reporting obligation for entities that are affected by cyber incidents which involve ransomware or extortion payments. And, the purpose of this is really to enhance threat intelligence and response by affected entities. So what's important to remember on this is that it doesn't prohibit the payment of a demand to an extortion or extorting entity. It just imposes a reporting obligation if a payment isn't made. So these reporting obligations will come into force within the next 6 months. So it's the 6 months of the Cybersecurity Act receiving royal assent. So we're looking at about the 30th of May 2025. But there is also a mechanism that can enable these obligations to come into force sooner if the Parliament decides to proclaim it as a earlier commencement date. So the 3 elements of when reporting is required. Firstly, a cybersecurity incident as defined in the Act must have occurred, is occurring, or is imminent, and that incident has or has the possibility of reasonably being expected to have a direct or indirect impact on a reporting business entity. The second element is that there needs to be an extorting entity that's made a demand of that reporting business entity or a third party, which is directly related to the incident that impacts them, in order to benefit from the incident or the impact. And then lastly, that reporting business entity provides or is aware that there's another entity related to it that is providing a payment or benefit to that extorting entity that's directly related to the demand. So a lot of direct connection that is required in terms of meeting the bar for when a report needs to be made. And all three of those limbs that I've just talked through are required to be satisfied in order for a report to be required. In terms of who this obligation applies to, it will be applying to private sector entities that carry on a business in Australia with an annual turnover that's equal to or greater than an amount that is to be prescribed by the rules that is still yet to be made. But what the explanatory memorandum to the Act has indicated is that the threshold is likely to be at least 3 million Australian dollars. So that's quite similar to the small business exemption threshold under the Privacy Act. So what that means in practice is that entities that are subject to the Privacy Act, APP entities, will also be required to follow this mandatory reporting requirement if they suffer a cybersecurity incident and there's a ransomware demand and payment made. The obligations also apply to some larger entities that are responsible for critical infrastructure assets that are already regulated under the Security of Critical Infrastructure Act. So these are the larger insurance businesses, general insurance entities with total assets over $2 billion. Critical life insurance businesses are those with total assets over $5 billion, and critical health insurance businesses with assets over $500 million. So they're already regulated in that space. Under the reporting regime, the reports must be made to the Department of Home Affairs within 72 hours of making a payment or becoming aware of such payment being made. This will be done through a portal that is going to be on cyber.gov.au, and that's going to be administered by the Australian Cybersecurity Centre. The critical infrastructure asset owners that I just mentioned, those who already have those obligations are already required to report mandatory cybersecurity incidents under that Security of Critical Infrastructure Act. So because they've already got those reporting obligations, it'll be quite familiar to them in terms of the existing reporting portal that they need to use. It'll be a similar portal for this new obligation. And then turning to the minimum security standards for smart devices, this legislation or this part of the obligations will enable the minister to prescribe mandatory security standards, again, via rules under the Act for internet or network connectable devices. So it could capture quite a broad scope of different devices. And it also imposes obligations on manufacturers and suppliers of connectable devices to be producing statements of compliance with mandatory security standards. And it establishes an enforcement regime, including a potential stop sell and product recall obligations. So these obligations become effective within 12 months of the Cybersecurity Act receiving royal assent. So we're looking at 30th of November in 2025 before that regime will come in. But after that 12-month implementation period, manufacturers and suppliers of relevant connectable products will then need to meet these mandatory security standards. At this point, those standards have not yet been developed, but once they are, those suppliers will need to work with manufacturers and others in the supply chain to make sure that they comply with these requirements at that point. Over to you, Tatiana, on implications for the industry.
Yeah, so, when you're in the situation where, cyber security breach happened, there are lots and lots to think about. And we know many firms actually run stress test scenarios and almost practice dry runs of these things and suggest having protocols and train these things. So in addition to everything that you already need to do in relation to loss of data and the information of the Data and Privacy Commissioner, you also need to think about this, which is just adding more things to your plate. On the flip side is, so there is a penalty if you don't do this, but as Yvonne said, there's no penalty to pay ransomware. So based on our understanding, the government kind of is trying to step up and understand what's going on, because up until now they don't have any data of how much money is being paid, how, what, to whom, and so on. So I think it's all in all, it's probably a good development. However, it does pose a operational challenge when you're actually in the situation. And we've been kind of studying and researching this, and even up to the point when something like this happens, people's blood pressure goes up. They lose sometimes their ability to think clearly. And, you know, in that case, it's very important to have a partner who you can trust. And I know that a lot of insurance companies provide this kind of service where you have a hotline and, you know, somebody will help you walk through the protocol of what you need to do in a less heated and panic mode, because they do this day in and day out. So yeah, cybersecurity is everyone's priority, has always been. It's just now in the law. So that's the difference. If you were running a really good risk management, and you know you've defined your risks well, technology risks, I would say, probably take half of the space in the current risk registers if you're detailed about them. So those things should have been on your radar a while ago. Now the difference is they're just kind of written in the law. And finally, as we say, always invest in prevention rather than in, you know, dealing with the problem as it comes. All right, let's go into the connected one, the privacy update.
Yes. So this is another piece of significant legislation that was passed on the 29th of November this year. That was the last Parliament sitting day, which is why they were very busy making sure that this all gets through Parliament before the Christmas break. And although this is a piece of legislation that's still awaiting royal assent, so we don't know for sure when some of the commencement dates will kick off, it is a long time coming. There's been recommendations, review, making sure that the Privacy Act actually is fit for purpose for the digital age and to better align it with privacy laws internationally. So this legislation that's now been passed is the first wave. There will be possibly more to come in the future in 2025, but we'll just go through a few of the notable reforms that have been now made as part of this piece of legislation. The OAIC, which is the Office of the Australian Information Commissioner, they've received enhanced investigative and monitoring powers as a result of the legislation. It broadens the types of sanctions that are available and penalties that are available to the OAIC. So they'll now be able to issue infringement notices for privacy breaches, which will allow them to bypass the courts. There's been an introduction of civil penalties that match the severity of the breach. There's expanded court powers to order penalties beyond monetary penalties, as well as expanded powers for the OAIC to be investigating and monitoring certain regulated entities, and empowering the Information Commissioner to conduct public inquiries. So they've been given quite an arsenal of tools to play with, and it obviously sets the tone for the types of regulatory enforcement actions that will be coming down the line, particularly with the enhanced cybersecurity requirements and also new transparency requirements on the use of automated decision-making systems. So this is very timely considering the use of AI, as we've already discussed at length during this session. These new transparency obligations will require APP entities, which are the ones that are covered by the Privacy Act, to disclose when automated decision-making systems use personal information to make decisions that could significantly affect individuals' rights. So this will be applicable when an entity is using a computer program to make decisions or perform tasks that are directly related to decision-making. And the decision could reasonably be expected to significantly affect an individual's rights or interests, or personal information about the individual is used in the operation of the computer program. There is a 2-year grace period for APP entities to review their automated decision-making systems and to comply with these new transparency requirements. What it means in practice is that APP entities will then need to start disclosing in their privacy policies details about the kinds of personal information that are being used, the kinds of decisions that are made solely by automated decision-making systems, and the kinds of decisions for which an automated decision-making system does a thing that is substantially and directly related to the making of the decision. So these reforms will be of particular interest to any businesses that are looking to incorporate AI-driven automated decision-making systems. And really, to stay ahead of the curve, you can already see those that's the way that regulation is going towards. Businesses need to be reviewing and updating their privacy frameworks, particularly as those automated decision-making systems are becoming integrated into various parts of your business, to make sure that you're complying not just with the existing legislation, but what is about to become required very soon on the horizon. There's also a new introduction of a statutory tort. So this is the first statutory right for individuals to sue businesses directly for serious invasions of privacy. So what this new right will allow is for individuals to seek compensation with non-economic damages that are capped at just under $500,000. This is a right that will require a plaintiff to establish 3 key elements: that there was an invasion of a plaintiff's privacy by intrusion upon seclusion or a misuse of information. It needs to be a situation where the reasonable person would have had an expectation of privacy, and the invasion needs to be serious and intentional or reckless. So whether a plaintiff's claim might be successful under this new statutory tort might also depend on demonstrating that protecting the plaintiff's privacy serves a public interest that outweighs any competing public interests that might be raised in defence by an organisation. What we're expecting is that there will be increased litigation that comes off the back of this new statutory tort, given that it empowers individuals to directly seek redress against businesses for serious privacy invasions. And it will be important that privacy compliance measures are put into place to make sure that you're limiting the extent of any frivolous or vexatious claims that might be made under those new rights, so that you can focus your attentions on those legitimate claims that might be coming through in relation to this new statutory tort. Lastly, in this space, there is already an existing requirement to take reasonable steps to protect personal information that an APP entity holds from misuse, interference and loss, as well as unauthorised access, modification or disclosure. So this appears in the existing Australian Privacy Principle 11. And now what's being proposed under this new Privacy Reform Act is a new APP 11.3, which provides that reasonable steps that are referred to in APP 11.1 will include technical and organisational measures to protect personal information. So this is mirroring some language that already exists in the European GDPR regulations. And in the event of a privacy breach, these technical and organisational measures are the ones that will be assessed by the regulator to determine whether they were reasonable under the particular circumstances that might be reviewed. So in terms of what these measures might include, the explanatory memorandum to the legislation does provide some examples of what's considered to be technical measures. So organisations might decide to protect information through physical measures, software, hardware, whereas the organisational measures that are referred to here might include steps and processes that an entity should implement, such as employee training on data protection and that sort of measure. So the bill itself doesn't really provide a lot of practical guidance, and what we're expecting is that the regulator, the OAIC, is going to provide some more detailed guidance in the coming year. Tatiana, any views from your?
Yeah, so practically, I'm not sure if you're familiar with the information security standard, the global one, the ISO 27001. A lot of these things are kind of standard for this. So as I said, the title here, The Long Road to Australian Privacy Reform, it's almost closing the gaps of what's been out there in different countries and international standards to date. If you're familiar with that, I'd say it's a good place to start practically. All right, we have 7 minutes left and still 2 big topics to cover. So let's try to do this.
Okay, this is the one that I foreshadowed earlier in the session about consent that will be required for retail commissions going forward. So this is the result of a tranche. It's the first tranche of reforms that follows the Quality of Advice Review final report that was released in February 2023. This new piece of legislation is aimed at conflicted and banned remuneration. So what it will require is Australian financial services licensees and authorised representatives who provide or are likely to provide personal advice to retail clients, so likely to capture insurance brokers, they'll need to be obtaining informed consent from that client before they can be paid a commission on insurance products that they arrange. So this is a requirement that applies to general insurance products, certain life insurance products, as well as consumer credit products that are issued or sold after the 10th of July 2025. ASIC has released some guidance on this requirement through their information sheet 292 and also an updated regulatory guide 246, which is around conflicted and other banned remuneration. But in a nutshell, to comply with this new informed consent requirement, insurance brokers and other licensees who provide personal advice to retail clients need to be obtaining a client's informed consent to receive the benefit before the insurance is issued or sold. They need to also have the client's written consent or a copy of it, or a written record of any verbal consent that was given by the client. And as soon as practicable, after the client has provided this informed consent, they need to then give the client a copy of that consent, whether it's written or a record of a verbal consent. Now, before a client is considered to be providing informed consent, the broker or the person providing personal advice to the retail client must disclose certain information to the client. And this includes the name of the insurer of the relevant product, if that's known, the rate of the monetary benefit that the broker will receive, which should be expressed as a percentage of the policy cost. They'll also need to give details around the frequency and period over which the broker will be receiving that monetary benefit, as well as the nature of any services that will be provided to the client in relation to the product. There also needs to be a couple of statements that are in the disclosure. So there needs to be a statement that it's a requirement of the law that the consent from the client must be obtained before the payment of an insurance commission, and a statement that the client's consent, once it's provided, it's irrevocable. And when it comes to renewals, a new client consent will not be necessary if the information is disclosed to the client before they agreed to that product, still remains unchanged at the renewal point, and that the rate or frequency of the monetary benefit is less than what was previously disclosed. For general insurance, the initial consent must include renewals, and for life risk insurance and consumer credit insurance products, the expected renewal periods must be also included in that initial consent in order to rely on the exemption for renewals. But if it's the case that the rate of the monetary benefit is higher at the renewal point, or the frequency is proposed to increase, then a new or varied consent from the client will be then required for the renewal. And for clarity, any brokers do not need to meet the informed consent requirement if the renewal relates to a general insurance product that was first issued or sold before the 10th of July 2025. So really it's a go-forward position from the 10th of July onwards next year. And at a high level, ASIC is really expecting that any information that is being disclosed to clients in this space is to be worded in a clear, concise and effective way that actually gives clients a genuine and real opportunity to make an informed decision. And even though there is no express requirement to provide a copy of that client consent to the insurance product issuer, this might still occur as a part of any compliance or risk mitigation strategy to make sure that there's no conflicted remuneration given in contravention of the law. Tatiana, any thoughts?
Yeah, very briefly, it seems straightforward in terms of what it's required. However, our basic advice is start early, because we know that it's actually very hard to turn your operations and, switch it in one day. So you still have approximately, half a year to do that. Especially when it comes to systems and processes. If you want to automate some of that stuff, it's not as easy as, just flip the button, that. So, and controls. If you automate it, please make sure that you check it regularly and pick up any irregularities. Okay, other confirmed regulatory changes that we did not talk about are CPS 230. We've spoken at length about it. Financial accountability regime, same, and climate, we did touch upon that. There's a question here from Mark. How is this practical to obtain? It's a great question, Mark. There must be a record of it. So if you're using any kind of systems where you either take notes or you let the client fill out certain things and so on, you might actually either ask them or kind of put a consent on their behalf and say, okay, yeah, do you agree? I have informed you and so on. But it's going to be, that's why I'm saying start early. And if in doubt, I think ASIC always has pretty open doors for questions like that, and say what I'm considering and what I suggest doing. Will you be happy with this? Will you see this as a control, and will you see this as a evidence that I've actually done this? So, all right, we are at time. So I would suggest we won't take more of your time. We still had one more regulation on the GICOP. We'll pause it here. Before we go, you can please pop another question in the chat, but I'll ask you to fill out the last poll that would help us structure our agenda for next year. If you please, just entertain us for one click of the button and tell us what would you like us to give you more information on in the coming year. So there's a scroll button here. And if it's something else, just type it in the chat if something else is there. People still want CPS 230. Okay. If you're interested in CPS 230, we already have quite an extensive body of information and research and recording. So just let us know and we're happy to share it with you. This climate regulation rubbish. Okay. Got it. Consent for commissions. All right. All right, so as it seems, commissions take 40% of the votes, and then the next close ones is CPS 230, and a lot of people are posting climate in the chat. So I think this is kind of in line with what we were thinking about. All right. Look, we'll leave the GICOP for later. It's just the one to keep on your radar. There's no rule or regulation yet. We just wanted to share kind of the interim process and that. But thank you so much for tuning in. We're over time. We've tried to package a lot to make sure you go into 2025 well informed. So thanks again. If any questions and so on, you know our email addresses, so just let us know. All right. Thank you.
Thanks, everyone.
Happy holidays.